providers in accordance with the new law starting June 1st. And then Section 32 repeals the existing law, and Section 33 on page 29 sets out the transition. So you can see at the top in subsection 1, any registry identification cards issued to the people with the medical conditions, so people the new bill calls registered card holders. Anything issued prior to the effective date of the repeal of the issuance of cards would be valid until the expiration date that's listed on the card. So there would be a gradual phasing out of those cards. And then under the remaining subsections, the department could start issuing new registry identification cards to both patients and providers starting June 1st under their emergency rules. And until October 1st, they could issue those cards for providers without having the results of fingerprint background checks. That was one of the concerns that was raised during the House hearing on the bill, that if all the providers had to get new fingerprint checks, it would be very hard to process all of them by July 1st when caregivers would no longer be allowed. So you could, the department could be issuing those cards. If somebody did not submit fingerprints by October 1st, or if their fingerprint check came back and said they were ineligible, then they would revoke the cards they had issued under the emergency rules and notify the card holder that the provider they had named was ineligible. And then on subsection 4, just some clarifying amendments to the fact that if you're a caregiver right now and you do not become registered as a provider before July 1st, you have to take your inventory of marijuana plants and products to local law enforcement on July 1st so that they could be destroyed if you have not been registered as a provider by then. And the remaining sections are pretty much clerical sections. I did put down at the bottom under effective dates the sections that would be effective on passage and approval and what they are. So the bill would go into effect July 1st, including the repeal, except for the following sections. The section prohibiting advertising, the section repealing the issuance of new cards, that would go into effect on passage of approval, and so the amendments related to that, sections 28 and 29, would also be effective on passage and approval, as with the emergency rulemaking authority, the transition, and the instructions to the Code Commissioner on how to coordinate with other bills. Mr. Chairman, that's it.
Thank you very much, Ms. O'Connell. Questions from the committee? Representative Smith.
Mr. Chairman, I have a question for Ms. O'Connell. Do we need to have any coordination language in there for, and I forgot the bill number, but it's the bill that was out there that was for the businesses?
Mr. Chairman, Representative Smith, I've amended all of that language into the new section that has limitations on the use of cards, because there was one section of the existing Medical Marijuana Act that was amended and would be repealed. So I've taken the language that was in that section and incorporated it straight into this bill, so we don't need to coordinate further. It's done that way.
Thank you.
Representative Barry.
Mr. Chair, Ms. O'Connell, I guess a clarification on page 15, lines 23, 24, and 25. You've crossed that out, but where are we addressing that later on in the bill? You say you've coordinated that later on in the bill.
Mr. Chairman, Representative Barry, it's actually addressed on that same page up higher on lines 15 and 16. So if you have a card and you're ordered by any court into a correctional facility or program, so that would be the prisons, a pre-release center, a supervised program of some kind, the boot camp, then you couldn't use marijuana. So that's one spot. And the second spot is on line 17. If a court imposes restrictions on your use pursuant to the provisions added into that new section that I've pulled in, the sentencing laws. So even if you're not in a correctional facility, you're out maybe on supervised release, any court could put restrictions on your use and say that you could not, that your registry card was suspended during the term of that sentence.
Part of your conditions of pre-release or parole or something like that.
Mr. Chairman.
Thank you very much.
Ms. O'Connell, I'll just follow up to that question. So specifically, if DUI court made the order, that would apply, this language would apply. if a person was released by the Department of Corrections to a pre-release center, this language would apply, and that pre-release center or
Mr. Chairman,
direct court supervision could prohibit the use.
yes, Mr. Chairman, that's correct. Any sentencing court could revoke a card or put limitations on its use. And actually, when you are released into a pre-release facility from the Department of Corrections, you are still under their custody, and so that would work as well. That goes into effect.
Thank you. Further questions from the committee? I see Senator Larson's 5-minute conference committee has turned into an hour and 15 minutes at the moment. Well, we've got about an hour, so why don't we begin substantive discussions. For now, let's skip over the whereases and just turn to the language that was inserted on page 2. And members of the committee, at this point, I believe the Senate Bill 423 is in the form that it left the House, and in order to adopt a change, an affirmative vote by representatives of the Senate and the House voting separately is required. Is that all? Does everybody else agree with that procedure and my understanding of the rules? Okay, so let's deal with the issues we can. If we hit a spot we can't agree on due to Senator Larson's absence, we'll just have to defer that and return when he's able to join us.
And Mr. Chairman, if I could just mention, Pam right now is handing out the unedited version of the amendments that we just went through, so that, as you can see, a lot of them are internal references and technical small changes, and that's why on pages where I thought there were more substantive issues you wanted to discuss, I indicated the page number and the amendment number on this document.
Okay, so let's start with amendment number 5 then. I think in terms of staying organized and making clear the record is clear, let's vote on the unedited version of the amendments. And I think we'll just have to, in terms of their impact, I think we'll just have to jump back and forth from the unedited amendments to the red bill, as Sue referred to it, and oh, I see. So not every change is highlighted in red, Ms. O'Connell.
Mr. Chairman, I did not highlight every internal reference change.
Okay. So I think members of the committee, we've got 3 internal reference changes. They'd be numbers 3, 4, and 5. Could I get a motion to adopt those? That appears on page 1, line 28, page 1, line 30, and page 2, line 4. Just because sections were added to the House bill, this is an...
So moved, Mr. Chair.
Okay, any discussion? Would question being